Okay, we're all gonna go ahead and get started now. Thank you so much for joining us on a Saturday morning. We're very excited to see all of you. This is the panel that's focusing on state judicial diversity. Before we dive in, I have just a few housekeeping matters that I have sworn I will go over. Please make sure your cell phones are either off or on silent. Is that better? There we go. Thank you. We will have a question and answer portion, although we'll be keeping it a little bit shorter because of the time running over in the plenary. I'll leave about 15 minutes. Because we're recording this session, we ask that when it's time for questions, you go up to the microphone so that your voice can be recorded properly. If you would like to tweet this session, the ACS handle is @ACSLaw, and the hashtag is ACS16. Finally, the final piece of housekeeping, this session is available for CLE credit, and so if you'd like CLE, there is a table outside of the session that you can speak with folks afterwards. So with that, let's dive in. I'm just going to give you a little bit of an overview about the kind of the issues that we're going to encompass in this session, and we're going to try to keep this lively and conversational today. So during the keynote on Thursday that I know many of you attended, Senator Warren and Vice President Biden both focused on the importance of the judiciary and public confidence in our system of justice. They explained, though, that one of the biggest threats to our judiciary is the lack of diversity. So Senator Warren explained that professional diversity is missing from the federal bench and justice suffers for it. The importance of demographic diversity has also been a hot topic in the news thanks to Donald Trump's attacks on Judge Curiel. However, federal courts are only one small part of our judicial system. So approximately 95% of cases are heard in state court, not in federal court. And these courts are incredibly varied in the types of cases that they hear and how the judges who sit on these courts are selected. So just two quick statistics to help paint that picture. 36 states and DC use a judicial nominating commission to select at least some of their judges. So these commissions play a role in recruiting, evaluating, and recommending a slate of candidates to the appointing authority, often the governor. Even more states, 39 states, use at least some form of election, either in their initial selection or in their reselection of a judge. And there's huge diversity even within the types of elections we see. So there are partisan contested elections, nonpartisan contested elections, and the little understood retention election, in which a judge basically stands for a yes-no vote, and they are not contested. So despite the vast diversity of how we select judges, we don't have a lot of diversity in who these judges are. And so that's really the topic of today's panel. So with that, let's dive right in. So I'm going to start with you, Michelle. Michelle is the Vice President of Legal Progress at the Center for American Progress, and her many expertises include the court system. Michelle, I'd love it if you could talk a little bit about why state courts are so important and what they do.
Great. Good morning. We're still morning, right? I know. My name, again, Michelle Jawanda. Do I have anybody here from UNC Law? Yeah, that's right. But you're my friend already, so it doesn't count. Well, it is great. I always appreciate the opportunity to be here at really what is the preeminent conference for, I would say, progressive thinking scholars, academics, and law students all around the country. So it is great to be with you again. I'm at the Center for American Progress. Who's familiar with CAP and our work? So the Center for American Progress is a progressive think tank, but we often say that we're somewhat of an action tank. While we recognize that ideas matter and are important, you also have to have power to bring those ideas into action. And so that's what CAP is. A few years ago, we started the Legal Progress team really to fulfill the answer and help to answer the question, what is a progressive view of justice? So many of us think about the executive. We think about the president quite often. I am a former Capitol Hill staffer and was chief counsel to Senator Kirsten Gillibrand from New York, and a lot of people are familiar with Congress. But what we don't often think about is the judiciary. It's like the forgotten third branch of government. We learned it in civics class, if you have civics, and then you forget about it. But it has such an important role in our lives. And often, even less talked about and considered is the role of state courts. So if I told you that 95% of the cases that are handled in this country are handled in state courts, 100 million cases per year. Most people are like, what? And they don't think about that at all. But state courts are really oftentimes the first interaction that the American people have with the justice system. So who in here has ever gotten a ticket? Don't lie, okay. So there's that interaction, but there's also interactions around family law and obviously the criminal justice system. Much of it happens in state courts. And so for the average American, they often think that Chief John Roberts probably adjudicated a traffic ticket at some point in his life. That is their conception of the role that judges play. I don't think the Chief Justice would appreciate my analogy, but it's true. And it is important for us to also think about it in that way, because the importance of that being the first interaction that so many have forces us to think about, when they have this first interaction with the justice system, what does it look like? When you think about where our country is, right now we are in the midst of a massive demographic shift in this country. By the year 2060, right, so to give you a few numbers, by the year 2060, and I want to make sure I get this right, my team always gets on me, right now, in 1980, the population of the United States was 80% white. Today, the population is just 63% white, and by 2050, that number is projected to drop to 44%. Today, Hispanics constitute 17% of the American population and should be 29% in 2060. Asians are around 8% today and should be 15% by 2060. And the numbers for the African American population are expected to grow slightly to about 16% by 2060. So we are in the midst of a changing America. As early as 2044, the majority of the population will be comprised of people we now consider to be minorities. So when we think about that, we should also recognize, so what does the state courts look like? There are so many friends who work on this issue, we find that right now, based on the data that is publicly available, only about 8.4% of all of our state court judges are people of color. 8.4. And when we talk about gender diversity, only about 26%. Half of the population are women. And yet, by the time we look at who sits on the state courts, a little bit more than a quarter, and less than 10% are people of color. And we've had a great conversation thanks to this guy named Donald Trump. Just a side note, I'm from New York. And so I kept on waiting for someone to say, like, oh, you've been punked, because I could not believe that this was happening. But I digress. When we think about the fact that Donald Trump in some ways articulated a thought that a lot of people have. I have some of my colleagues, we worked in the Senate Judiciary Committee. There are a number of senators who don't articulate it the way Donald Trump did. But if you were a judge of color and you would go for a hearing, there would be certain questions that were given to candidates of color that were not given to white candidates going before the committee. Could you be fair? Could you be impartial? And so what has happened is, in some way, we have set the standard that whiteness, and typically male whiteness, is the standard for impartiality. And everyone else, whether it's a woman or a person of color, brings a set of biases. But what's been interesting is if we think about it, bias is something that we all deal with. It's implicit, and it's important for us to recognize it. If you juxtapose what happened in the Stanford rape case, the judge in that case was a former Stanford athlete. And when he looked at that young man, the empathy that he felt, because he said, you know what? He's someone who I recognize his background. I think he can do more. No recognition to the victim, but I understand that young man. I think he deserves a second shot at life. There was a bias there. And yet we don't typically acknowledge it in these places. And he was a state court judge. So I know we're going to get into a conversation a little bit later about some of the specific obstacles at one of the papers we recently released looked at judicial elections and how they have some of the effects on people of color when they seek to run for re-election. So we'll talk about that in further detail, and I'm really excited. But I wanted to set the stage and start to challenge us as we begin to move forward in this conversation. Thank you so much.
Thanks, Michelle. So Michelle has painted a pretty grim picture about what our courts are looking like today. So I'd like to turn it over to Judge Reyes to talk a little bit about why we should care about this grim picture. Judge Reyes was appointed to the Minnesota Court of Appeals in 2014, and before that he was in private practice. This coming November, Judge Reyes will face a nonpartisan judicial election, but he has recently learned that he will be unopposed in that election, and so will be sitting for another 6 years. So, Judge Reyes, why should we care?
Well, I think we should care because, first and foremost, we're lawyers and judges, and we should care what the judiciary looks like. Second of all, the state judiciary, as you heard from the numbers in terms of the cases, that's where the rubber really hits the road. That's where the vast majority of people have their first contact with the judicial system, is on the state level. And you have it not only on the district court level, but also on the appellate level. I'm on the Court of Appeals. We have 19 judges on the Court of Appeals and 7 justices on the Minnesota Supreme Court. And diversity is, I believe, incredibly important for us to be able to reach a fair and just decision. Because when you get the perspective of people with different backgrounds, different legal training, different geographic diversity, gender diversity, racial diversity, when you get those different perspectives all together, I truly believe we end up with a better result. On the Minnesota Court of Appeals, we have 19 judges. Of those 19, we have approximately half are men, half are women. We have geographic diversity. That is actually part of the statute. 12 of us, including myself, are at large, and then the rest represent different parts of the state of Minnesota. But we have people that were prosecutors. We have people who were public defenders. We have people like myself that had kind of a mixed career. I worked at a law firm, then went in-house counsel for a dozen years, then went back to private practice as a partner before I was appointed by Governor Mark Dayton to the Court of Appeals. But I also started my career as a judicial law clerk. I had the privilege of clerking for the Honorable Salvador Rosas, who was a state district court judge. And I saw firsthand the importance of diversity on the bench, because when he was up there on the bench, and we were on the criminal rotation the entire time, I clerked for him for almost 2 years, when people of color saw a judge that was up there who was also a person of color, you could see that look in their eyes that they knew, okay, this is somebody that looks like me. I might actually be listened to by this person. And he did. He showed them tremendous respect. He carefully listened to what they had to say. And even if he was sending them to jail for 2 or 10 or 20 years, they knew that he took into account their story, their experience, their background, and what they were going through. So I've seen firsthand the impact that diversity on the bench can have I've seen it at the state district court level. I see it on the appellate level, and I see it also on the Supreme Court with the decisions that they have as well.
Great, thank you, Judge. To my right is Judge Blackburn Rigsby. She has been a judge in the District of Columbia since 1995. Since 2006, she has sat on the District of Columbia Court of Appeals, before which she sat on the Superior Court of the District of Columbia and as a magistrate judge on the Superior Court. Judge, I'd love for you to talk a little bit about your experience with judicial diversity in the District of Columbia and why diversity is particularly important on that court.
Well, good morning, everyone. And good morning. It's a Saturday morning, and I'm so happy to see all of you here in steamy Washington, D.C. Why is diversity important to the judiciary? What do we mean by a diverse judiciary? And why should we all care? I echo many of the comments from my fellow panelists, but I think we have to start from the perspective that we live in a democracy that I believe is one of the most wonderful gifts that our country gives to us. And it's not a perfect democracy all the time, but it's up to each of us as citizens in this democracy to work to make it better each and every day. And I think we are beginning to lose sight of what it means to be a part of a democratic society that has three co-equal branches of government. And the judiciary, I think, is the most mysterious branch. And I think first and foremost, we have to begin to demystify this third co-equal branch of government. And I will tell you a funny story to digress for a minute, but one of the roles that I've had outside of my court responsibilities was to serve as president of the National Association of Women Judges. And one of our recent projects was called Informed Voters, Fair Judges. And we were looking at states where judges were elected. And what we discovered was that people don't know what courts do, really. They see TV judges, they see TV shows. They don't often know what courts are supposed to do and what they're supposed to look for in a judge. And I don't mean to suggest for any moment that judges should be above criticism and above evaluation and from the community. But I think if you understand the different role that the judiciary plays in our democracy, and you inform the community what a fair judge looks like and what considerations go into selecting or electing fair and impartial judges. And I use those terms, fair and impartial. I don't mean that judges should be robotic and numb to the concerns of the community that they serve. But when you have a diverse judiciary, to get to the specific question, you have a diverse judiciary that is fair and impartial, and the number one reason I think it's important is because it instills public trust and confidence in the courts. And a recent ABA, American Bar Association study, looking at courts and how the community perceives courts, public trust and confidence in the courts was lacking, particularly in minority and underserved communities. And one of the reasons is because the judiciary as a whole doesn't always reflect the communities, the diversity of the communities that it serves, racially, ethnically, gender-wise, and experience-wise, and even class-wise, if we wanted to get real about it. Now, I don't mean to suggest, and I hope we touch on this, that just because you are a diverse judge, an African-American woman or a Hispanic man or an Asian woman or a transgender gay or lesbian judge, does that mean that any time a litigant who's African-American comes before you that you're going to rule for that person? No. Does it mean that an African-American woman is going to decide the law differently from a Hispanic man? No, I don't think it should mean that. But what it does mean is that the discussion and the discourse and the richness of experiences that come to bear when people come before the courts is broadened. And judges who are in management in trial courts, deciding policies and procedures for the trial court, benefit when different diverse judicial voices discuss the policy of how the courts will deal with the public. On an appellate court, and in the District of Columbia, our District of Columbia Court of Appeals is our highest state court, if we're describing it. We all know that the District of Columbia is not a state, but our DC Court of Appeals and our DC Superior Court are our state court judiciary, even though in an interesting twist, the judges of our Superior Court and our Court of Appeals are nominated by the President and confirmed by the Senate in a similar manner to the confirmation and selection of federal judges. So when you talk about an appellate court, I think the importance of diversity is even perhaps clearer and easier to see because appellate judges decide cases in panels. Our court typically sits in a division of 3 judges unless we sit en banc as the full court of 9 judges, although we're currently down 1 judge, waiting for Senate confirmation. But on an appellate court where you discuss the cases and you have to try to come to a consensus, there you see the value of different perspectives, not just on the levels that we typically talk about diversity, but career-wise, life experience-wise. It's vital to have that diverse voice, and the discussion is richer and broader, and the ultimate opinion or decision of the court is too. So I think I will stop there, and I know we'll have other questions, but that's why I think diversity is critical.
Judges, I'd like to push you a little bit to talk about why diversity is important on trial courts. So as Judge Blackburn-Rigsby just noted, it's easier to see the impact in an appellate court where a panel is convening and judges are influencing each other. But in the Stanford swimming case, for example, that was a trial judge. Even if we have a diverse court, we are still likely going to have privileged white men from Stanford on the bench, and trial court judges have enormous discretion in sentencing. And so will diversity really solve that problem?
Well, I'm not sure if diversity will solve the problem, but I think what it will do is, even though on the district court level, it's just the 1 judge that's on the bench and ruling, you're still really part of a team. You're still part of a group of district court judges, and they talk to each other. They assist each other. They bounce ideas off of each other in terms of cases that they're dealing with and recommendations, and so there is a discourse that happens behind the scenes. Now, each judge is responsible for their own case, but they're going to have that influence and the input from other diverse judges on their court. So I think that's at least one way where the diversity really can have a positive impact at the state trial court level.
I also want to tackle head-on what might be a bit of a prickly topic when we talk about diversity. That sometimes it is raised in this false dichotomy that either you have qualified judges or you have diverse judges. Mm-hmm. And I just want to say that is unfortunate way to look at things. And we start with the value of diversity to strengthen any institution. I think diversity is what makes our country strong. I think diversity is what makes all of our public institutions strong and our private sector institutions stronger. The corporate sector has embraced diversity as a business value and as a core value. And so when we turn to the courts, I think we need to start with, first and foremost, it is an important value that benefits us all. And it is not a false choice between either we get qualified judges or we get diverse judges. That quality judges and wisdom comes in diversity. The second point I wanted to make is that in the District of Columbia, we are a very diverse city, but we also are a city that has a majority African American population, but it is shifting and growing, and we have an increasingly international population. In DC, like many other courts across the country, we have court documents published in 9 or 11 different languages. And the leading language, second to Spanish, is Amharic, believe it or not. We have one of the largest Ethiopian communities. So diversity comes in different ways. We have very diverse judiciary in the District of Columbia. Our trial court is nearly 50% women, more than 30, almost 40% African American, I would say. And we have Latino, Asian judges. So we have a very diverse judiciary. But diversity in numbers, and my second point I wanted to make, is not enough necessarily without a constant and vigilant institutional focus on fairness and access, and what that means to the litigants coming before the court and the people that we serve. So you can have a court system in jurisdictions that may not be as diverse racially and ethnically, that is still diversity-minded and values fairness and access for all segments of the population. But you have to be vigilant, and you have to focus on that as a core value for our justice system.
Great. So, as many of you likely know, conversations about judicial diversity often only scratch the surface, and so thank you for digging in instantly. This is great. We've talked a little bit now about why diversity matters and why our state courts matter, but despite the fact that diversity is so important, we actually haven't known very much about the composition of our courts. So the most recent complete race and ethnicity data has been extremely outdated, and calling it complete data was a bit of an intellectual fallacy. But thanks to the incredible work of Professor Tracy George and her collaborator Albert Yoon, we have a stunning data set that they will be releasing soon, providing the biographical characteristics of courts of general jurisdiction. And I'd love to turn it over to you, Tracy, who is a professor of political science at Vanderbilt Law and director of the school's litigation and dispute resolution program.
Thanks, Kate. So I want to thank everyone for attending the panel today, showing interest in this topic, but I owe special thanks to my co-panelists for participating today and to the American Constitution Society. So the report and the results that I'm going to discuss were funded by the American Constitution Society, but all research was carried out by independent researchers at Vanderbilt Law School, where I work, and at the University of Toronto, where my colleague Albert Yoon is a faculty member. So let me tell you a little bit about the origin of the project by describing what it is that before this project we really knew about the composition of state courts. So state judges, obviously, judges in general are very important, but as has already been described, state courts are particularly important. They are America's courts. When we think about important rulings, whether rulings that affect the lives of individual people or rulings that make law, state courts dominate that discussion and dominate the law that we experience. So it's very important to know who serves as state judges. They're very powerful public officials. Therefore, you would expect states to be transparent in disclosing information about who sits on their courts, at least giving us the names of the people who sit on their courts. It turns out that is not true. With some exceptions, states are quite opaque in describing who sits on their courts, while there are exceptions where there are some states which provide exhaustive biographical data or information about their judges. Very few do. So we know very little about who serves on state courts from the states themselves. And existing sources on which many people rely are simply unreliable. They come from anecdotal evidence, outdated information, and in some cases just mischaracterizations of existing sources of information. So given that, and given the centrality to knowing who serves on state courts, to the study of state courts and how they work, Albert and I undertook what was in fact a dramatically challenging project of trying to identify the judges who serve on state courts. And so the way we proceeded is we began by identifying all appellate judges and judges on general jurisdiction trial courts. Our data does not include judges who serve on specialized trial courts, which the majority of states use as part of their entry-level court system. We used amazing research assistants who work with me at Vanderbilt and with Albert at Toronto. We have some amazing Vanderbilt law students here today. I didn't have the fortune of working with them on this project, but the students were terrific. And we used well-established techniques for identifying sources that are reliable, doing validity checks as well as reliability checks on the data, and just generally monitoring. So our resulting data set, the state bench database, includes over 10,000 judges, including both the judges on this panel, representing 147 courts in 51 jurisdictions, and it's those courts as of December 2014. So what did we find? So I'm going to focus only on the principal findings. The full report and an interactive web page will be released. Right now our date, I think, is June 20th for that, so you'll see more about this. But let me at least tell you a little bit about our principal findings. And so the first thing I want to focus on, I know it's a little hard to see on the slide, and so I'll describe it more, is to use as a comparison the population of the United States. So the U.S. Census actually collects population data in between the official census dates that we use in social science. And so our current numbers in the U.S. population, and here I'm going to lump together people who are of color, so anyone who's non-white or white and Hispanic, according to the categories of the census. White men make up only 30% of the population in the United States as of 2014. But by contrast, if you look at the trial court and the appellate court in the states, white men account for 58% of trial court judges in the United States and 57% of appellate judges. I would love to tell you those numbers improved a lot if we looked at U.S. district judges, magistrate judges, and courts of appeals judges. They do not, although Article III judges, the numbers have improved pretty substantially over the last decade. Most notable to me, and the biggest surprise, was the underrepresentation of women of color on courts at the appellate and trial level. You'll see that while 20% of our population is made up of women of color, only 8% of our judges on trial courts and appellate courts are made up. So let's step back and try to get a bigger picture of this. And if you look at the state court judges combined in the next graphic, you'll see that when we look at the American people, 51% are women, but only 30% of state judges are women. 38% of people are people of color, yet only 20% of people who serve on our courts, who make those important decisions, are people of color. So we created two different metrics for trying to evaluate the results that we found. One we call the Gavel gap, which is the name of the panels, the name of the report that will come out. But another way of getting at the Gavel gap is to think about representation. So if you didn't know the composition of a state court, you might start by asking, what's the composition of the population? How many white men are there in the population? How many white women are there in the population of a state, right? Let's predict that that will be the same representation that we would see on the state courts, and then look to see how far it falls short or is overrepresented in the state. So we did that, and my data I'm going to show is going to be separating out race and ethnicity from gender to look at the results more closely. So let's start with the race and ethnic representation. So we might think about giving grades. I just turned in grades recently, and so I'm thinking in a grading metric, and everybody knows the grading metric, right? 90% and above is an A, 80% B, right? 70% C, 60% D, below 60% you fail. feel a little bit like the professor from Paper Chase when I do this. So let's start with the racial and ethnic representativeness. What you're going to see if you look at this distribution, beyond noting first that 32 jurisdictions, right, out of the 51 fail by this measure. What I think is interesting is it's a strange distribution. You actually have 7 states that are doing great. In fact, in those 7 states include states that have a larger representation of people of color on the bench than they do in their population, ranging from states that are predominantly white to states like Hawaii that are actually a majority minority. From a minority from the population of the United States perspective. And so you see how poorly the states are doing from this representative matrix. The result that was actually more surprising to Albert and I think, was the lack of women on the bench. And so if you look at the distribution of the states, while you have fewer states that fail, only 27 states fail on our metric, no states are close to parity. There is not a single state in the United States that has 90% of the representation of the general population on its court, which is to say has an equal or close to equal number of men and women on the courts. And this, notwithstanding the fact that for 40 years, women have made up a substantial part of law schools. Right, so if we think about this, and we're going to get to this later, as a pipeline issue, what's surprising is that from a labor economics perspective, we don't see this as a supply side problem. Okay, so that gives you a glimpse into the kind of data that we have and the findings we have and how stark they are. Obviously, what many people would like to know is more information about a specific state. And so one of the things that the website will have available is it'll be interactive, and you can pick. So on the website, you'll be able to pick a particular, you can look at all the states combined, look at appellate judges versus trial judges, or you can say, I'm from Georgia, and what I'd like to know is what is it like in Georgia? And when you pick Georgia, and this is my I have to concede, fairly ugly representation of what the web page will look like. Luckily, they defer to those with greater expertise to create these. You'll find out, we include age, so we'll give you the median age. So in Georgia, the median age of the judges is a little over 60. Gender is 23% of the judges are women, but 51% of Georgia's population. Notably, 85% of Georgia's judges are white, but only 54% of their population are white, non-Hispanic. So you'll get a chance to see the dramatic contrast. Georgia is one of the states that scores the worst on both measures in our data set. Or you could look at just the trial bench. So the web page will give you the capacity to ask these more finely grained questions. Because our goal is that people will use what we found to inform policymaking. Because we all, right, I think one of the wonderful things about the American Constitution Society is that we all embrace the idea of evidence-based policymaking. Facts matter. And so having this information, we hope will be helpful in informing the decisions and advocacy of people in this room and in other people looking at state courts. So that gives you a sense of our original findings, but obviously a lot more detail in the report.
Tracy, this is incredibly helpful in sort of understanding what the state of play is right now and what a crisis this is. As you mentioned, a lot of people argued, especially 10, 20 years ago, that as the numbers of women and people of color in law school increased, so too would diversity on the bench, and that alone would solve the problem. Clearly, that is not the case. Judge Blackburn-Rigsby, can you talk a little bit about what some of the obstacles have been to diversifying the bench in appointive systems? And just for our audience members, there are different obstacles to diversity on the bench and appointment and election systems, and so we're going to start with a conversation about appointment, but we're also going to chat a little bit about the elective systems.
Okay. I just wanted to make one quick point and how vitally important the data that Professor George and our colleague have put together is. I shared with our panel members that it was just in 2010 that I did a law journal article for the Howard Law Journal. I'm a Howard Law alum. And the topic I was asked to look at was African American women on state high courts or federal appeals courts. And I started from Reconstruction to the present because that was the historical time frame. And the data was almost impossible to find, current data about black women on state high courts or federal courts of appeals. We almost had to call every state courtroom clerk and ask, and they didn't always want to share the information. So this is a real game changer. The other thing I noticed in my research in that article was that interesting historical milestones also triggered the advancement and increase in diversity on the bench. So during Reconstruction was when we began to see the first African American judges, but then we went through a period of retrenchment and backlash against blacks in this country. When the women's movement was in its early stages, seeking women's suffrage, and shortly after the passage of the amendment giving women the right to vote, shortly after that we begin to see the first women appointed to state courts and then to the federal court. And it's interesting here when we seem to be at a point in our country where the debate about race and gender and diversity is at a pivotal point where we need more voices saying loudly that diversity is a value that's important to all Americans and that makes our country stronger, rather than some of the other voices we hear trying to in some ways, I think, retrench on some of the important gains we've made that have strengthened this country. But my question was about barriers to diversity in an appointed system. Our DC system, as I mentioned, is unique among state courts because as the District of Columbia, our judges are nominated by the President and confirmed by the Senate. But before it gets to the level for the President to select a nominee, we have a local judicial nomination commission comprised of representatives appointed by our mayor, our council, our local DC bar, and the President of the United States. And that commission reviews all applicants and recommends 3 names for each judicial vacancy to the President. And I will say, interestingly, my bio is not atypical. I was nominated to our trial court by President Clinton and confirmed by the Senate, but I was nominated to our DC Court of Appeals by President Bush, George W. Bush, and confirmed by the Senate. And I say that because historically, the judges in the Congress, Senate and the White House have not politicized as highly the judges that come through our DC nominations process for our local courts. And so I think that's a model that can work. So we have a diverse bench, and we have judges appointed routinely by Republican and Democratic presidents to our court, and they really haven't gone through as highly partisan politically charged confirmation hearings as some of the federal judicial nominees. So I think our system is one that works well. I think our commission has, in recent years, taken steps to make the process more transparent. Community forums on how you become a judge. Most people don't know. What makes your application stand out? What kinds of experiences is the commission looking for? And then the commission also does targeted outreach to the women's bar, to different minority bars, so that the word spreads about what the process is and how it works, because for a long time it was very mysterious to many people. And so those things have helped a lot.
Great. Judge Reyes, is there anything that you'd like to add from your experience with nominating commissions in Minnesota?
Yeah, so in Minnesota we have a nominating commission as well. We're one of the 36 states in the union that uses that for state appointments. Although what's interesting is, bless you, is you don't need our Minnesota Judicial Selection Commission is required to vet candidates for the trial court judges, but it's not required for the Court of Appeals or for the Supreme Court, which is something that's a little different. It's a little bit of a hybrid. Nonetheless, we've had most of the governors, Republican, Democrat, and independent. We did have an independent governor, Governor Jesse Ventura, in case anybody remembers the body.
Memorable.
and those governors have all used that Judicial Selection Commission almost all the time for the Court of Appeals appointments and for the Supreme Court. When I applied to the Court of Appeals, I was interviewed by the commission. I think one of the keys to increasing diversity on the bench is increasing the diversity, quite frankly, on the commission. Mm-hmm. That's the decision-making body right there that makes recommendations of 3 to 5 candidates to the governor for a final appointment, interview and appointment by the governor. But if the commission isn't diverse, you've already got an initial hurdle to overcome. And I found interesting the data up there about women of color in particular. And by way of background, I was president of the Minnesota Hispanic Bar Association in 2000 to 2003. I was president of that organization for 3 terms. Interestingly enough, after that, they put a term limit so you could only be president for 1 year. I have no idea why they did that. But after that, then I became involved in the Hispanic National Bar Association and ultimately became national president in 2012, 2013. Throughout that time, for about 15, actually more than that, 15, 17 years, I was very, very involved in identifying and vetting and endorsing candidates through the bar associations, both on the state court level and on the national level. In fact, the HNBA, when I was on the board, we vetted and endorsed Justice Sonia Sotomayor, as well as Justice Elena Kagan, who came to the HNBA for vetting and endorsement as well. So I've seen it from both the state level and the federal level. One of the things that I did observe, and this is just an observation, I don't have any hard data to support this, but I will tell you that it seemed to be more of a challenge for women of color. It was a challenge for people of color in general and for women, but women of color, it was, and oftentimes it would be under the judicial demeanor or judicial temperament.
Mm-hmm.
Yes, where you would see for some candidates of color, women of color, if they came off as being too timid, the criticism that was received back was, well, they just don't seem to have enough judicial temperament, not fortitude, or I don't know if they'd really be able to handle the courtroom. If they came off as too strong, I'm not so sure she'd be able to, I think she'd be too abrasive in the courtroom or on the bench. And so it was really a fine line that we had to walk in terms of when we'd be working with them and doing prep sessions with them. And so it's important to have that diversity on those commissions too, so they can say, no, she's not too timid at all. She definitely has the temperament for the bench. She'd do fine on the bench. So commissions is one area where I think it's very, very important to have diversity as well.
The perceptions of what appropriate female and appropriate judicial behavior is certainly not held exclusively by nominating commissions. Voters also have sentiments about these things. And as I mentioned at the beginning, judicial elections are a big part of how we pick our judges. Michelle, would you be able to speak a little bit about some of the unique challenges in judicial elections and also some of the similarities?
Thank you. So racial and gender biases definitely serve as biases when you are sent before us, the citizenry. So for instance, we have recent evidence that suggests in low information elections, voters rely on racial and gender stereotypes as shortcuts to understand who those judicial candidates are. And that's particularly true, again, we see for Latinos and African Americans. It's particularly true for judges with Latino or ethnic sounding names. We have data that suggests there are many judges who have lost their seat to qualified opponents because they had more white-sounding names. So one of the best examples is a candidate who was not recommended, was basically given one of the worst one of the worst qualified ratings from one of the judicial kind of ABA commissions, and yet because her last name was Kennedy, and she was going against an African-American woman, she actually won, and the other judge, who was highly recommended, did not win. I think it is important as we talk about these issues that we are also very explicit with naming bias as we see it. I think it's important to start there, because we often put the onus on candidates of color or women to be a exceptional or superior candidate and fit into a certain mold. And the reality is that there is not enough training or mentoring or pipelining that we can ever do to rectify those numbers. What we're talking about is really looking at an overall system and what are changes that can be made to different systems. So, for example, in our report, one of the disturbing difficulties that were raised by diverse judges is that the overall re-election rate, right? So in many situations, we were looking at judges who were either appointed or won outright the first time, but when they sat for re-election, for 90% of white Supreme Court justices, their re-election rate was 90%, while Latino justices were successful in only 67% of their re-election bids, and black justices had just an 80% re-election rate. One of the other obstacles that we now recognize pervade every aspect of elections is fundraising and the massive amount of money in elections, including now judicial elections. We recently saw one of the highest elections in the state of Pennsylvania, over $1 million elections. Every year, the Center for American Progress, we release a report of the top 10 $1 million judicial races in the country. I think most Americans do not think that we should be spending millions of dollars to elect our judges. And what we also recognize is that women and people of color, some of the same challenges that they have in partisan or political elections and running for office, we also see those present in judicial elections. So the same network and access to donors, the same fundraising challenges. There's always the viability question that we see in elections for women and people of color, that we are now seeing those same questions of viability for our judges. And there should not be the same criteria. So I think that those are some of the challenges, and I know we'll talk about more.
Great. So it is Saturday morning still, and so we're going to try to keep this moving in a positive direction and talk about some of the solutions to these problems. And I want to make sure we are able to turn to that before we get questions. So Tracy, I'd love for you to talk a little bit about why some states are more successful than others. And Judge Blackburn-Rigsby, maybe you could talk a little bit about ways in which states that are not as successful could take steps to promote diversity.
So thanks. So I would love to tell you that we know why some states are more successful than others. In fact, that was part of the original project that Albert and I had planned to pursue, in the belief that we would be able to readily find information about who serves and would not invest a great deal of time being the first to provide an exhaustive data set on who sits on state court benches. So we have not done that yet, but let me talk briefly about hypotheses that we have and what the next phase of our study will be. So the hypotheses come from many areas of social science. You know, we can rely on labor economics, we can rely on political science, sociology, psychology. Indeed, The speakers today, right, Judge Blackburn-Rigsby, Judge Reyes, Ms. Jawando, have all provided compelling narratives that can serve as the basis for building hypotheses about why we see the composition of the courts that we do. So, for example, method of selection has to matter. How you pick judges will affect who serves as judges. That is not surprising. How it has that effect, I think the descriptions here that are provided about processes in different places is not entirely clear. We also have to assume that the terms and responsibility of being a judge is going to affect who serves as judges, dynamics within the legal profession, including pipeline, both from the legal profession and from law school. I think there are a lot of hypotheses that the way we plan to test is to use both quantitative and qualitative methods, right? So the qualitative methods, interviewing, trying to get a sense of how individual judges actually secured their employment is very important to telling the story. And we're getting some of that today, and I really think you're incredibly fortunate to hear from two judges who've been successful at getting appointed, or well, both were initially appointed to the court, adding to that in a systematic way. But nevertheless, I do think that we need quantitative analysis. We need to understand if we're going to propose changes that should be made to selection systems. One thing I want to look at, so just let's look at one example. I think pipeline matters a lot, and that's what you're hearing from the judges today as well. So here's a pipeline story. We have women are 51% of the population and about 48% of law students today. In fact, they've been at about the 50% mark for more than 20 years. But they're only 36% today of the legal workforce, right? And they're only 30% of state court judges. Where are they going, right? Where are the women going that we're investing in as a society to train as lawyers? Why are they not ending up on state court bench, and trying to understand that? So I think the pipeline is going to be part of the story. I think that power dynamics inevitably will be part of the story. I want to pick up on something that Michelle said that I think is really important. I think that we have to recognize as well that a lot of this is a voter story. The majority of judges in the United States face election as part of their selection. Recently in the California State Court retention race, we had a great natural experiment where we had minority judges with non-minority sounding last names who did much better on the retention votes than minority judges with last names that sounded like minority names. We don't know that that's what caused the difference in the vote, but it's a very good place to start, I think, in trying to understand the dynamics. So the answer is I don't know. I've been writing a lot of notes based on what the speakers have said to inform some model building.
Well, just to pick up on where Professor George left off, I think the pipeline is important. And what do we mean by that? That one of the things I observed, and this is not that long ago, just 6 years ago from when I did the research for my law journal article about African American women on state high courts, the result surprised me. When I undertook all this study, I could actually count them on both of my hands. Now, in the last 6 years, that's changed a lot. We've seen a few more appointed to the federal circuit courts, and moving up from the state trial court level to the state intermediate appellate courts and to the state high courts. But in creating a pipeline, I think you have to have some intentionality. I use that word. You have to be intentional about it. And again, that doesn't mean that we look for diversity and forget about qualifications. I think that they are intertwined and that we have to look for it intentionally. And one of the ways that I have seen this done, I'll start first with my work with the National Association of Women Judges, for example. We have had a program, one of our signature programs, called The Color of Justice, working with girls in elementary, middle school, high school, college, and law school, and young lawyers in the profession, to expose them to judges, to expose them to a judicial career, to get them thinking about what things they need to do. Law schools, many law schools have, many undergrads have pre-law programs, and many law schools do. And I had wonderful opportunity yesterday. Howard University School of Law, historically black university, took students from HBCUs, or historically black colleges and universities from around the country who are undergrads, and brought them this summer to Howard Law School to begin meeting with judges and lawyers to talk about what you need to do now to prepare yourself for a legal career and to think about being a judge. Another important pipeline, and this is something I think judges can do as judges, and I have been asked, the American Bar Association has a project focusing on the role of judicial appointments to important bar committees and important roles. For example, as receivers, special masters, lead counsel in multi-district litigation, lead counsel in large class action lawsuits, and to members of various court committees in state courts around the country that make policy for the courts. These are high visibility appointments for lawyers, and they are often made at the discretion of judges. And Roberta Liebenberg from the American Bar Association Commission on Women just completed a study showing that the lack of diversity in these appointments is pretty shocking as well, and surpasses some of the gaps that we've seen in this study. And that we need a study like yours to look at the way judges exercise their appointment powers, because if you're not getting these high-profile appointments as an attorney, when it comes time to put in an application to be a judge and you're going up against applicants who've had these opportunities for visibility in the profession, you're at a loss. And so I think judges, by just asking the makeup of court committees, how many receivers or special masters or lead counsel of diverse backgrounds have been appointed, and keeping track, I think will help to begin to increase the diverse pool of lawyers who have the background and qualifications that we think enhance them as judicial candidates.
Judge Reyes, I'd love to give you an opportunity to add anything to that conversation about what judges can do. While Judge Reyes is answering, you are officially on notice. It is almost question time. And so start thinking about your brilliant questions, and you can line up behind that microphone there.
I think one of the challenges in this area, I think sometimes why you see diversity fatigue, people start getting frustrated or tired working in this area, is because there's no silver bullet. There's no one solution. I think that Judge Blackburn Rigby outlined some wonderful ideas of what can be done. Some of the things that I've been involved in and that I've seen that I think are beneficial is judges just speaking out on this issue. That we're limited in terms of what things we can say, but this is one of the areas that we can speak about and speak about very boldly. And I think we as judges need to do that. Second, I think we need to practice what we preach. I think judges need to make sure that the clerks that we are hiring as well are diverse. I've tried to do that myself. Over half of my clerks have been women. I've had a Vietnamese law clerk. I've had a Chinese intern. I've had a Middle Eastern. That's how he describes himself, so I'm going to follow his lead. Law clerk, right now I have a Latina. This coming fall, I will have a Latino and a female African-American law clerk joining me. So it can be done. It certainly can be done, and quite frankly, I think that's an area of opportunity for the judiciary. I was fortunate enough to have that opportunity as the first stage of my career to be able to be a judicial law clerk, and that really that was very, very life-changing for me to be able to have that opportunity. I think a third area is with bar associations. I've been very, very active and continue to be active in the ABA, Minnesota State Bar Association, MHBA, HNBA, and one of the things that we've done on the local level is we have been working closely together with other bar associations to develop the pipeline of future potential candidates. We just had a program recently, it was kind of a pilot one, about identifying candidates at the early stages, mid stages, and people who are ready to apply right now for openings. and it was a joint project between the Minnesota Hispanic Bar Association and the Affinity Project, which seeks to increase the number of women on the bench. We've also had programs with all the bar associations of color, the Lavender Bar, the Infinity Project, to really introduce not only lawyers but also law students to the idea of thinking about eventually at some point in their career becoming a judge. We also have done this on the national level with the National Bar Associations. I was fortunate when I was national president of the H&BA to work very, very closely with colleagues, the other bar presidents. We ended up developing and forming a program called the Collaborative Bar Leadership Academy to develop the future bar leaders of each of our organizations, and we did that in conjunction also with the ABA. So it's, that's an area as well where we're working together closely, and the bar associations endorse other people of color as well. I just ran into Judge Srinivasan a couple days ago here and had a chance to talk to him. When I was H&BA president, the H&BA endorsed him, so we had a chance to catch up and chat a little bit. So I think there's a lot of that collaboration is also key.
Great, thank you. So I'm going to open it up to questions. The one final note I want to add is that it's not just the role of our judges, but it's all decision makers who should be taking steps to increase diversity on the bench. So for voters, that means educating ourselves about the judges and taking steps to make elections as participatory as possible. I also just want to add as a note that the Brennan Center for Justice just released a manual for judicial nominating commissioners, providing the concrete steps that they can and should be taking to more effectively build a diverse bench. And so for folks looking for those concrete steps, it's available on the Brennan Center's website.
Thank you. This has been such an engaging panel, and I have so many questions. I will limit it to one. I'm Joanna Scavone. I'm an appellate lawyer. I practice in San Diego. I own my own firm and have a practice both civil side, but largely represent indigent criminal defendants as an outside panel attorney who gets appointed in state and federal cases. And one of the things that I find affects my practice and my clients more than even demographic diversity is experiential diversity. And we haven't really talked about that as much today, but I think it's something that's really important in terms of collecting data or feedback, and judges in terms of providing their perspective on how that affects deliberations among your colleagues, because I often get questions from diverse demographically and also experientially diverse candidates who are not willing to apply because they don't think they have a chance. And so building power or data or information around that to get the political willpower to appoint experientially diverse candidates. For example, in California, we've seen a sea change under Governor Brown, who is actually willing to appoint public defenders and former in-house counsel, et cetera. So I wonder if you can comment on that, about how we can encourage candidates who come from experientially diverse backgrounds, which actually, frankly, there's a lot more demographic diversity there. So I wonder if we can fold that into the conversation, and if you have any thoughts on how that makes a difference.
Great. So just a note about timings. Thank you. I'm going to unilaterally decide we could probably go like 1 or 2 minutes over since we started late, but I want to make sure that we get as many questions as possible. So my suggestion is that we get a second question, and the panelists can address both questions together, and then we'll do the same for the next two to make sure we can get these questions on tap. And I will summarize the questions for the panelists afterwards to make sure we're on the same page.
Hi. So the panel has spoken very extensively about systemic changes and changes that we can make for judges who are currently in positions of power, et cetera. What can law students or those of us that are just entering the profession do as individuals to encourage diversity in the bench?
Great, thank you. So the questions are about experiential diversity and what young lawyers and law students can do to help promote diversity.
Let me take a stab at the experiential diversity. I'm so glad that you brought that up, because that is so important. And as I said, you see it very clearly on the appellate level, but I think it's also, as Judge Ray said, very vitally important at the trial level. And one quick anecdote to get to this is, I remember deliberating with a 3-judge panel in a criminal case where the defendant had stolen an MP3 player that was fully loaded with music and apps and everything. One of my colleagues was much more senior in age than I was, and then that the other colleague on the bench was, and just couldn't understand what the big deal was about and how this data being loaded up on the MP3 player had increased the value, therefore ratcheting up the nature of the crime. And in the course of our discussion, got it, but he was like, well, I don't understand. This is just a little device, fits in your pocket. What's the big deal? And there's an experience gap. I'm sure not like you're talking about, but it's how the dialogue and another way it comes into play is socioeconomic level. Oftentimes on the trial court, when I was a trial judge, judges would think that they were helping by not incarcerating a litigant, but instead they'd make them come down to the courthouse 3 times a week to drug test and report, and that meant sometimes 3 or 4 buses to get, even in a city of this geographic size with no car, to get downtown, loss of time from work, child care, and when the person would fail to meet those requirements, then they would end up revoking the release and incarcerating them. And so when you have a diverse group of judges with experience with different populations, either working, being from, a member of, having family members, that helps to inform the discussion. And then on the law school piece, coming to events like this, being involved in different campus groups, being intentional about having discussions on campus, all of those things help. And I think it's important to get involved in bar associations as a law student. All different bar associations have student divisions. And then lastly, as judges, I loved what Judge Reyes said about how judges also seek, if you value diversity, going out when you're applying for a judgeship and seeking support from a variety of bar associations is important, even if you're not a member of that particular group represented by the bar association, because it shows that you value diversity.
Yeah. I would just quickly add on the experience. I completely agree with you on that. When I joined the court, we have 19 judges on the Court of Appeals. One of the things that was very gratifying is I spent a majority of my career in-house counsel, and as you noted, oftentimes that's not what they're looking for. I did litigation as well, and I did work at a firm, but that was the majority of it. When I joined the court, one of the common refrains from my colleagues is, we're so excited to have you join because now we've got somebody with business experience and understands how corporations work and businesses run. And I have found that I will go, we have people on the court who have expertise in real estate and family law, criminal law, prosecutor, public defender, and that insurance law, and we have a diversity of experiences and expertise that we will regularly go to each other to say, I just want to make sure I'm on the right, I'm not going too far astray here. And I've had them come to me with issues dealing with business or contractual disputes as well on a regular basis. So I think it is really important.
And I'll just add 2 quick cents. I would say, one, pushing both nominating commissions as well as ABA because of the role that they play, and recognizing and valuing those experiences. As an advisor to my senator, because of both the professional backgrounds that we brought to the work and to the nominating commission, there were different skill sets that we valued that you don't always see. So I think that that's one thing. Quickly, for the law students, we talked a little bit about some of the pipeline issues. I would say definitely implicit bias training for law school admissions officers so that they can recognize some of the roles. So if you're a research assistant working in admissions, that's one of the things that you can make a recommendation. The other thing is, if you're in a state that has either a ballot referendum or reforms that are looking at public financing for judicial elections or things of that nature, get involved even as a law student, because recognizing overall that will help everyone in the system.
So let's have the next 2 questions, please.
Good afternoon. My name is John Patterson. I come from the diverse state of Oregon. And I'm also one of the specialty bar leaders for the National Bar Association chapter out there in the Oregon Judicial Diversity Coalition that works to increase diversity of our state court bench. And one of the problems that we've run into is that candidates of color who have put themselves up for office or up for positions have felt burnt out because they put themselves up 2, 3, 4 times, they don't get appointed, and then they kind of say, never mind. What advice do you have to tell these candidates or to tell the other candidates who are into traditional feeder pipelines of big law, public defenders, or the district attorney's office that they are still important and that they should keep putting themselves up and not get burnt out?
Great, thank you.
Don't give up, and if you're not in the race, you can't win.
I think that's a great question because one of the things I find that many candidates in the District of Columbia who are planning to apply, I've gotten calls from many of them, but fewer of the minority candidates call than other candidates. And I think sometimes my message when I go out and talk to minority bar associations and people who are interested is that you've got to cast your net wide and ask for help. Ask a wide variety of people to look at your papers that are submitted. Ask them what was helpful to them when they went through the process. And I think too often, at the risk of painting with too broad of a brush, sometimes minority candidates feel like they have to do it in secret because they don't want anybody to know if they don't get it. So they put it in a stealth way. And sometimes you want to do just the opposite. You want to get support and assistance and feedback and critiques and prep before you put in your application and before you go for your interview. Because often I've heard that first interview is important. It puts you on the radar for the commission as a strong candidate who may just need a little more time, or this candidate's application was kind of sloppy. And then you get labeled in a different way. And I just offer that as a thought.
Great, so I think we're down to our last 3 minutes. So what I'm going to ask is if the folks in line, if you are able to ask your question in one sentence, you may ask the question. I will give all 3 of you the chance. And then I'll basically let every panelist give one final brief word. That way we can cram in as much democracy as possible.
Okay. Hi. How can students who attend law schools that push firm jobs or private practice still stay involved enough to help diminish the gavel gap, especially for communities of color? Thank you.
Great, thanks.
Frank Joikert from Seattle. I've worked on judicial elections for 28 years, mostly women and minority candidates. Wanted to question, especially towards Professor George, about where's the scholarly literature on what makes for successful minority and women candidates campaigns, and offer an observation that we need a panel like this next time to talk about the difference between the politics of appointment and getting elected, because most of what we've talked about today is the inside politics. You need a very different set of supporters who know politics when you're running for election.
Thank you.
Hi, I have a very short question. Are there any organizations similar to Emily's list that support judicial candidates who are underrepresented currently? Thanks.
Election, judicial candidates who are being elected or appointed?
Either, but mostly elected.
Okay, great. So I'm going to start at the end with Tracy, and the panelists can decide how and which questions they want to answer, but brevity will be encouraged.
The answer, I think, to all 3 is that there is so little but so much opportunity. If you are currently a law student or a young lawyer, you should consider becoming a judge. You should be a leader of your bar. You should be someone who wants to be heard and wants to have an impact. And you will simply by doing so. And so I think that speaks to all of these. We need to know more, but the good news is we're all working very hard to try to do that.
To quickly comment on a couple of the last questions, I think you can support and promote diversity in any environment as a lawyer. I started my career at a law firm, a large firm here in the District of Columbia, and if you are involved in voluntary bar associations and participate in the firm life, you can represent and speak out about the importance of diversity wherever you are. Judicial elections, I mentioned the Informed Voters, Fair Judges project of the National Association of Women Judges, which had Justice Sandra Day O'Connor prepare a video that actually won a short film Emmy Award. And it can be downloaded from the NAWJ's website with a toolkit just about generic role of judges in a democracy and why it's important for voters to elect fair judges. And then lastly, as a closing remark, this panel was very important. I'm so happy to be here. I believe that diversity is a democratic value, and it is what makes our democracy strong. And having 3 co-equal, diverse branches of government, of which the judiciary is one, is important to all of us for a stronger democracy going forward. Thank you.
There's a conversation that's currently happening right now in the legal profession about how we change and how we adapt. And so to you, the question about firm jobs, right now it's not going to be apparent. You're not going to feel it yet. So you unfortunately have to take some initiative to kind of break out of the mold that I think still for too many law schools the focus is get you in, get you out, and have a job immediately after graduation in a firm because they want alumni dues. The other thing that I'll say is to the gentleman about judicial elections, it's a conversation we have often. Unfortunately, I think one of the challenges that we face is should we be talking about some of the same skills that you need in running for partisan elections and judicial elections? And it's a value, it's a conversation that we're having as a profession. There are many of us who think that we should get out of judicial elections wholesale. It's not a reality, but can we imagine something different? I think that there has to be a little bit of boldness there, but you're right, that's a whole separate conversation. And finally, Emily's List, no. We should have one and you should start it. I think that there are tons of organizations that who could support your initial idea, but it is a wonderful one. The other thing I'll say is thank you so much for being a part of this conversation. It is always an honor and privilege. I would say challenge the places where you currently are. If they're not having this conversation, they should. And if they're not having the conversation, why are you there? And ask yourself, is this the type of environment, law school, firm, bar association that really recognizes the challenges that we face right now? And if it's not happening, then you fix it.
I'm just going to go to final comments because I think they hit on all the issues pretty well. My final comments really are, first and foremost, thank you very much for attending today. Thank you for the invitation to be here. I have my own notes that I've taken on the discussion, so it's been a learning process for me. But I would encourage all of you to continue this dialogue. I would encourage all of you to continue this discussion. Now more than ever, I think it is vitally important for us to talk about the need for diversity in the judiciary and why it is important for our states and for our country to be able to make sure that the courts are reflective of the communities that we serve. So thank you very much.
Thank you.
So, I'm David Lyle, and the director of the State Courts Project at ACS. And so I'm going to violate the prime directive here and make a very quick statement rather than ask a question. ACS, as Tracy mentioned, has sponsored this work. We were happy to do so, not because it's interesting, because it's important, not because the solutions to these problems are easy, but because they are hard. We are in this field for the long haul. We are building partnerships with leaders and organizations like those represented on this panel. But what ACS really brings to the table is all of you, all of your experience, all of your ideas, our chapter network, the great work that you're all capable of doing. And so through our chapter staff, through our program staff, and through me, we're gonna be talking, continuing this conversation into the fall and in the coming years, and I hope you will all be a part of it.
Great. So thank you so much to David and to Jill and everybody at ACS. I have one final duty as your moderator, which is to announce.
Thank you. You've been an awesome moderator, so thank you.
Moderating's fun. So my final duty is to tell you that the lunch program begins immediately in the presidential ballroom. Thank you all.